Break discussion. I am Cecilia Lazzaroni, Project Officer at the ETUC, and I will be asking the question at today's lunch break discussion on developments in the field of platform work in Switzerland. This is not the first event on platform work that the ETUC makes, but the third in a series. And so far we have already discussed the Lay Rider in Spain and developments in Italy. Today, as mentioned, we will focus on developments in Switzerland, and we have the pleasure to welcome here Regula Dick and Roman Künzler from UNIA. It will be possible all through the live streaming to send us your questions and comments by commenting in Facebook or on Twitter. We will try to reply to your questions. Before launching the questions and answer session, I will now pass the floor to Ludovic Wood, our Confederal Secretary in charge, among others, of non-standard and platform work, who will paint the introduction and the background for today's discussion. Ludovic.
Thank you, Cecilia, and welcome to everyone. I'm really happy to introduce this third session that we have live with our colleagues after the Spanish case, after the Italian case. We are going to have a chat during 30 minutes with our colleagues from Switzerland, and they live, even if they are not in the EU, they live situations that are really similar to those we are working on in the different member states. Of course, in the EU, we have the opportunity with the coming initiative on platform work to make our demands quite clear with the European Trade Union Confederation. But you will see today that there are really situations that echo really the situations that we live in our country. So that's why we wanted to have our Swiss colleagues on board today. Just to say a few words, recent court cases in the last year and different administrative and political decisions have shown more and more that platforms are still in breach of laws regarding the respect of workers' rights. And all these decisions recognize again and again the misclassification of workers as bogus self-employed, while the platform behaved often with the help of the algorithm management as an employer. So in this regard, the ETUC and the trade union movement have two ambitions: to win rights for these workers in platform companies, and also to make sure that the digitalization of the economy is compatible with the employment relationship and the respect of fundamental workers' rights. Again, last court cases that we saw in the EU, in Paris, again, platform that is Uber was sentenced against, and there was the court recognizes the fictitious nature of the Uber drivers' independence. So again and again, courts are stating that workers are workers and that they have to be recognized as such, that platforms are companies with the prerogative of employers, and that they have to be recognized as such. And this is what we will also try to have a look at the development of platform work in Switzerland to see how we can also bring what they live and what their struggle are in our daily fights. Thank you and have a good session.
Thank you, Ludovic. So you said that the situation in Switzerland echoes somehow what platform workers in other European countries live. And I would like to make my first question exactly on this point. So Regula, if you could please explain us what are the main platforms operating in Switzerland, the main platform or platforms, and what the conditions of platform workers are in Switzerland.
There are more and more platforms in Switzerland. They provide care service, nursing services, craftsmen's activities, food delivery services, driving services, cleaning services. And the situation is that these platforms, they try to pretend that the people who work for them are self-employed. That means that all these workers, they miss out on the social security protection for employees. They miss out on the protective rights of the labor law in Switzerland. And that means that they are very poorly paid because they are not seen as normal laborers. They don't fall under the collective labor agreements, which often have minimal wages in them. So the situation is quite bad, and I think a lot of them, because they don't have the social security, that the platforms don't pay for the social security. They are in great danger to become dependent on the social welfare system right now, or at least in old age, because nobody pays for the pension.
Thank you. So I heard that the situation is quite bad. Do Swiss trade unions have a strategy to tackle these abuses by platforms? What is being done concretely? Roman, if you could illustrate a little bit what's been done. So I'm not sure we hear you. I'm afraid we can't hear you, Roman. You may want to check your audio settings, and in the meantime, perhaps Regula can already start telling us something about.
Yeah, I think Roman would have liked to explain you about how he and other colleagues are trying to organize, for example, the Uber drivers. That's one major strategy we take, that we try to organize them and to make pressure against the platforms. Then what we also try to do is to influence the legislative process in Switzerland on the national level. One strategy was really to get expert opinions on various issues related to these platform employments. We try to sensitive with these expert opinions the members of the national parliament. That works quite well, and also the authorities. We try to bring them into the legislative process. So that also these members of the parliament, that they have the knowledge, also from a scientific side, how they can counter ideas of the right-wing members. Like, for example, they want to try to establish a third status for platform workers. This was one of the ideas of the right wing. That would mean that this worker class has less rights from the social security law or from the labor law. So we try to counter this idea with this influence into the legislative process.
Thank you. So we heard from you about two main fields of action, one concerning action in court, and the other trying to influence the legislative process. So also thanks to contacts with members of the parliament. I see that Roman is back online, and perhaps he can tell us a little bit more about not only your efforts in organizing platform workers and Uber drivers in particular, but also about what happened with Uber Eats in Geneva.
Sure. Can you hear me now?
Yes.
Okay, great. Because I just went out and reconnected. There was always a host muted you message that came, and I could not unmute in a sense. So, well, yeah. I mean, we're starting everywhere where we can by organizing concrete workers, and then to have concrete mobilizations that are the basis of after influencing institutions and legal procedures, and also changes of legal dispositions. So in Geneva, for example, you spoke about it. We had several mobilizations. We had 2 strikes of Uber drivers, and also even before Uber Eats came into the market in Switzerland, we did actions in front of the main clients, McDonald's. Also, there again, without the drivers, later with the drivers. And we see when we are organizing, have concrete committees in the back, we have much more legitimacy, also speak out publicly, and to make different states or the country act. Actually, in Geneva, then these actions resulted in a first worldwide, and this first was Uber Eats having to employ people with a contract. So I think they're the only Uber Eats driver which really have a contract, and Uber Eats is considered the employer. Well, it's not the Uber Eats directly, but it's a subcontractor of Uber Eats, but still they all have working contracts, the riders in Geneva, to the difference all over the rest of the country. And there you see that where people mobilize and organize, things can happen that cannot happen just by union power influencing institutions, etc.
Thank you, Roman. So we already see an important development in Switzerland, in Geneva, where Uber drivers have a real employment contract. But I think there are also interesting examples coming from the Canton de Vaud, especially linked to the conditions that drivers are entitled to in their collective agreements. Could you please tell us a little more about this?
Well, sure. By the way, I'm in Paris, Place de la République. There's a very impressive mobilization, mobilisation interprofessionnelle of the French unions. So that explains the noise in the background and the cannons, the cannon shots you hear. So, well, we have to say, I mean, we had to attack this problem on different levels. You know, we have court cases in the realm of social security going on, still ongoing, no definitive cases. We went with different Uber drivers to court, to a labor court, and one of is the case that you mentioned in Vaud, that we won. There was a definitive judgment that he had to be paid salary, you know, the costs of his car and social security. And there is the other level of that states are in litigation with the Uber company. So sometimes we just have to act, you know, in enforcing current legal dispositions, and sometimes we have to kind of stretch or invent new legal dispositions. That's the case of Uber Eats, especially in Geneva, where actually the canton, after pressure of the state, after pressure with us, they classified Uber as a temporary agency. So actually they're saying under Swiss legal law that Uber Eats is placing the riders into the restaurants. So they have to be treated like those kinds of agencies. They have to be authorizations. And they also fall under a collective bargaining agreement where that we have in Switzerland, which is binding for all temporary agencies. In Uber, the case in Vaud is just one victory. One driver won his rights. It's a breakthrough, but it doesn't change the situation. For now, drivers are still not having their contracts. They're still not getting paid their social securities, costs of cars, and salary correctly. So this fight will still be a long one. And it sees that it shows that a multinational corporation like Uber, they can game and play the system in Switzerland very effectively, and individual court cases don't change the whole situation.
Thank you. So we've already gone through quite a few points. Ludovic, would you like to comment them briefly?
Yes, of course, and thanks to the colleagues for their experience. And I think, as I said in the introduction, it echoes what we have as debate in the European and as fights in the different member states. What happened in Geneva shows that it's possible to bring Uber Eats after organization of workers. When workers organize, they can fight and they can win against a big company like Uber Eats. And yeah, it's only of course a starting point, but it brings hope that to show that it's possible to go to have a contract for the riders in Uber Eats in Geneva. So this is of course something that we will have to fight for all over Europe, and that it's not only applying to one canton of one country. So this is clearly one of the dimension we are trying to tackle at European level with the coming initiative. But also the second element that Roman was speaking about the canton of Vaud example, I think that bringing also it links to the one of the second demand that the ETUC has, is recognizing platforms as employers when they organize concretely the work, but as a company also, so with all the obligation that they have as companies. And this means that when they use the prerogative of employers, so organizing the work, as it is the case there, they have to be linked to the sectors where they are active in. And so they have to apply the collective agreement that unions have negotiated with the sector. And I think this is clearly one of the avenue of work for the future also, to ensure that there's a level playing field between the traditional economy and the platform economy, so that these platforms are considered as companies with the same obligations as other companies in terms of financing social protection, in terms of anticipating health and safety risk, in terms of providing, paying taxes, providing contracts, and respecting the different collective agreement provisions. So two helpful examples from two cantons, thanks to trade union action in Switzerland.
Thank you. So we heard two helpful examples, as Ludovic said. Regula, are there any other court cases that you would like to mention?
Mm-hmm. I think right at the moment it's quite an interesting time, because we are expecting new cases that go to the Supreme Court in Switzerland regarding the social security law. And one problem there is also because this Uber group is so diversified. It's for the Swiss Supreme Court. It's the question now will be which of this Uber group is the employer in this field, because they already decided it's not Uber Switzerland. So probably it's Resia Operations BV in the Netherlands. So that's also one of these problems we see, that this Uber group, it's not just one firm. It's very diversified, and it's sometimes difficult to find the right person to which you have to target. That's one problem. And then we had a very interesting decision some months ago from the Swiss Postcom. That's the postal regulator in Switzerland, because they said Uber Eats is subject to the Postal Act in Switzerland. They say to deliver food is a postal service in Switzerland, and that means that Uber Eats would have to go into oh, sorry, excuse me. That the labor union, as that it means that Uber Eats, they would have. Excuse me.
Someone really wants to talk to you.
Yeah, somebody really wants to talk to me, and I have to stop the phone now. Yeah, that they would have to go in. excuse me, really. Excuse me. Yeah, that was a very important important case, such to say.
Delivering food as a postal act.
Yeah, genau, as a postal act. It would mean that they have to go into negotiation with the labor union, and that's really an important factor for them. And they have to meet minimum requirements of employers, of the employers in the postal sector. So that's besides the two cases that Roman mentioned, it's very important in Switzerland right now.
Thank you. So at the beginning, you were talking about 3 branches of action. On the one hand, organizing workers. On the second hand, legal cases and court cases. And the third point was legal developments at federal level. We've discussed briefly with Roman the organizing of workers. We've seen quite a few very important court decisions right now. What about the developments, the legislative developments in Switzerland?
Mm-hmm. I think there's quite a discussion right now because right-wing politicians, they try to influence the Swiss authorities. They have new ideas like the third status for platform workers I already mentioned, or they also try to change the legal acts. They want to introduce in them that the workers, also the platform workers and the platform, that they can decide if it's employment or if it's self-employment. And I think that's bogus because all these workers for platforms, they are in such a weak position. They would never be able to say, okay, I'm a worker and I don't want to sign this contract. So we try to counter these new actions. From the right wing, we tried to introduce our own ideas. One of these ideas, for example, was that we would like to have in the law a presumption that the activity for platform company basically constitutes an employment relationship. That would mean that the platform, that they have to prove that the worker are self-employed. So right now it's different. It's always us or the court who has to prove it's a labor contract, and this was changed. It would change this proof, and that would, I think that would be a major point if we could make it in the Swiss law.
Thank you, and I think I can already ask to keep in touch with this, because this presumption of employment status is ringing a bell here at ETUC. But before giving back the floor to Ludovic for some final remarks, I would like to go back to Roman and ask him something more again on the Geneva case. So in Brussels, we heard that giving platform workers an employee status affects in a very important way the activities of the platforms. Has this been a case in Geneva? Is Uber Eats still operating in Geneva?
Yes, absolutely. They are operating. As I already said, they organized a subcontractor. Its name is Juskis, and they are employing directly the riders. So for now, yeah, there's also the minimum wage that the population voted for Geneva is applied to Uber drivers. So it's 23 Swiss francs, which is the best minimum wage in Switzerland. Absolutely. So they're conforming to the law, and they show that they can work also respecting the legal requirements. Whether they could do it worldwide with their business model, I'm skeptical. But maybe just to say, which I think what is really, really important before trying to find solution with these platforms or finding new legal dispositions, etc., it's extremely important that from the start to be very confrontative with them, attack them, make them disappear, because and delegitimizing their activities as taking out a lot of the social value and protection that we have as multinational corporations, just not respecting the rules that others do. I think only out of concrete confrontation and trying to chase them out of the country, there was then the next step coming on. I remind you that it was the state of Geneva that actually said you have to employ, and you're actually a temporary agency. And starting from there, they employed it for the first time. There's also court cases going on between the state of Geneva, Uber Eats, between the state of Geneva and Uber. So on the state level, on the country level, countries can take decisions to say we're not accepting the way you play the rules, and trying to win them in court. Then of course. So we're asking that of other states, more other states in Switzerland, which are really, really passive and actually play along the game that the platforms come in with. And the only thing we can do is organize and especially confront. And if then comes out a solution that is good for workers, like for the riders in Geneva, where there's still problems left, but it's a big improvement comparing to the other states, then it's great. And we also seen platforms just disappear again, and we have several mass layoffs in the last 12 months, 24 months, where 200, 300, 400 people were just laid off because the platform decided just to disappear. We fear this will be the case of Uber one day, and all that workers has been stolen from workers will be very difficult to get back. So we ask also the state to already have securities of these corporations, take some of hundreds of millions of these corporations, secure it someplace, and when they leave, then we have a secure amount of money that we can redistribute, give back to workers.
Thank you.
I would have a direct question to Roman. Roman, about Uber Eats Geneva, would you consider that as they subcontract this to another company, that some kind of bogus temporary agency work, so that after misclassification of workers as independent contractors, now they have to employ them, but they, I would say, find a way also to go through temporary agency when they could themselves employ directly the workers. So what do you think on that?
Absolutely, they're continue to find a solution where they're not responsible for workers. Under Swiss law, I mean, the state qualified Uber Eats as a temporary agency, and it's actually against legal Swiss law to subcontract a temporary activity. So actually, what we consider is that the construction right now is against legal law, but there is the case. The state of Geneva against Uber Eats on the decision that they are a temporary agency is still in court. So we are waiting the final decision. If the state wins, then actually Uber Eats has to engage or to employ directly the workers and cannot go to a subcontractor. This is for forbidden under Swiss law in this in temporary work.
Thank you. So we are certainly dealing with a quite complex topic and applied to a country with a quite complex structure. We've discussed developments at canton level, we've discussed federal developments, but I understand that there were some decisions, some rules that applied also at municipal level. I'm thinking about Bern and the fact that Uber driver services cannot operate there. Can you please tell us how the situation is for taxis there, and if there is an attempt to deregulate the market in some ways?
Yeah, absolutely. As you know, that the taxi sector is regulated all over the world. There is taxi laws on different levels in different countries. So because it's actually a public form of public transport, and some regulation and protection of clients has to be put in place. This is done on several all over Switzerland. Most of the states, the cantons, they say, well, Uber is not a taxi, so the laws are binding for taxi companies. They don't apply for Uber. So very neoliberal position. And in the canton of Bern, the taxi law is better, which actually the text of law explicitly covers also the Uber activity. And that's why there is some Uber, but they're not really, they don't have, there's some cars that drive for Uber, but not more. So they're actually not present. So you can say that the local communities on the city or state level, they can more or less outlaw Uber if they choose. And we have a direct democracy, so many things could be done. For sure, political parties, unions, taxi drivers, Uber drivers, they have not resorted to all the possibilities they have to have better legal dispositions where they operate. But it's also quite difficult. It's difficult to have an initiative, to collect signatures, to bring it to a vote, etc. So smaller constituencies like taxi drivers, and maybe with their unions, they're not very organized in unions. They don't have big resources. So for now, there is no initiative taking place in that sense.
Thank you. I think that this is a very good point to conclude our questions. We hear that communities, consumers and unions can have an impact, even though it is, of course, difficult and requires efforts. Before passing the floor to Ludovic, I would like to thank you again, you and Regula, for being here despite technical obstacles and being in a manifestation in Paris. Thank you very much. Ludovic, the floor is yours for conclusions.
Thank you, Cecilia, Roman, and Regula. I think really interesting cases here that we have. So yeah, maybe as I said, the Uber Eats case in Geneva is really interesting for us. It's possible to reclassify people as workers. They are workers. They have to have a contract. Often this case is used by employers association and by platforms to say that there's a collapse, that it's impossible to work with the employment relationship. We know it's not the case. And of course, if you give a full-time contract, but that you split all these hours over 4 people, of course, there will be less people working. But that's not an argument. That's not an argument. We need to create quality jobs. So if there's place in one city for 100 drivers, of course, if you cannot split all the incomes they can do over 400. So this is also a political choice that we have to do. We cannot play with poverty of people. Second case, Vaud, Canton of Vaud, the link with the collective bargaining agreement and the sectors where the platforms are active in. I think really interesting point that we also need. We also have this case in Italy, and we see that that's somewhere we have to go. Bern, the last case that was brought in the discussion, it is possible for a municipality to impeach Uber to operate on this in the municipality. So this is also the case that we heard from Barcelona in Spain. So it is there's no Uber in Barcelona because there are also here political choices that have been done to regulate it otherwise. So if municipalities and canton in Switzerland can do things due to workers' pressures, due to union actions, why not the EU? Why not the member states? So we see that a lot of pieces are done all over Europe, and we have to take this action now. I see also that our colleagues are proposing the presumption of employment relationship. This is also what we are proposing in the European debate. And what is really interesting is that this last week, the European Commission published the second phase consultation of social partners on platform work, where they ask employers association, but also trade union organizations to answer on what legislative action has to be done at European level. And we see that our proposal of presumption of employment relationship is at the center of the discussion. That the question of misclassification of workers cannot be hidden anymore, and that it is the center of the discussion at European level. So this is, of course, thanks to all the work that is done all over Europe by workers to organize themselves and to defend their rights. I would just say that what are our demands? As I said, presumption of employment relationship, but this is not enough. This has to be complemented by a reversal of the burden of the proof, because as our colleague said, the most vulnerable in the relationship, the worker, cannot be responsible to prove the situation of employment relationship, because he has no financial resource to go in front of courts, because he has no time to go in front of courts, because he has no knowledge to go in front of courts. It is easier to ask the platform who has all the knowledge, all the resources, and to prove what is the actual situation of the employment relationship. If someone is really a self-employed, or if someone is indeed an employee. So this has to be complementary. Presumption of employment relationship and reversal of the burden of the proof. This need also, as I said, to consider that these platforms are companies, and if the presumption of employment relationship applies, they are employers with the obligations that go with it, with the obligations to apply the rules that exist in the sectors where they are, that social partners have bargained and that workers have won all over the years. This need, we need then to be clear that it's impossible to conceive that we need a third status. So they are on one side, they are self-employed. They want to be genuinely self-employed. And on the other hand, they are workers. They want to be respected as workers. So there's no space for a third status, and there's no need for a third status. So this is why we really want to have a European initiative that covers these different angles and that ensures that there won't be a third status and that all workers will be treated respectfully, that they can have a contract, that they can have access to social protection, that they can have access to collective bargaining, and that all platforms are covered in this initiative, because from one day to another, a platform that is operating with even with genuine self-employed can change from one day to another the general conditions of the platforms if they see that they can concretely organize the service, they can concretely, as employer, organize the production in one sector. This is the only way we can ensure a level playing field in the sectors with a traditional companies that are respecting the laws, and we already have as unions demands to traditional employers that are respecting basic laws. So here we have to bring back platforms that are outside of the laws in actual laws to ensure that we can have a better future for the workers in the platform economy, and that this transformation of the society is compatible with labor and social rights. That will be all from my side for today. Thank you for having listened to us, and thanks to all the colleagues from Switzerland to have shown their fights that are really similar to what we live in all EU member states. So have a nice day and see you soon.